Hi friends, how are you doing? I hope you're all doing well. It has been a long time I have not made any video due to some personal reasons. Well, today I'm gonna to make an interesting video here, a very interesting discussion here rather. Uh, before, as you all know, we have a very important chapter in our constitution, that is fundamental rights, contained and incorporated in part third of the constitution. There are five fundamental rights in our constitution. The first fundamental right is right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. These are five rights, and from Article 14 to Article 35 cover these fundamental rights. Today, the point of my discussion is that is state. State is defined under Article 12, but it is not a fundamental right. Then why it has been included in the chapter of fundamental right? Why? This is the question. Why there is need to define it? Why there is need to comprehend the scope of Article 14? Sorry, Article 12. A state which defines state, because it is the state which abridges or which takes or abridges away a fundamental right, right? And it is a state and individual needs a constitutional protection against the state. We claim constitutional protection against the state, and state takes away our fundamental right. And finally we go to the court, we approach the court against the state. It's not an individual cannot abridge any fundamental right. So so simply, it is always a state, not an individual. Now now what is state? State has been defined under Article 12. There are four things included, rather four points included in the definition of the state. The first definition, it says unless the context otherwise requires, right? The first thing, that is the government of parliament of state, sorry, India, the government and parliament of India, that is it is understood as executive and legislature of the union. And the second thing is government and the legislature of the each state, that's executive and the this legislature of states. uh, the third thing, that is all local or other authorities within the territory of India. These are the these are the three points among the four, which are very simple to comprehend. That the fourth one is, that is all local or other authorities unless under the control of the government of India. All local and other authorities under the control of the government of India. Now, the expression here, other authorities, it's ambiguous, it's uncertain, it has not been defined clearly. Now, here the role of Supreme Court comes in. Supreme Court, you see, if we will see the meaning of the authorities, that is from the law perspective, it means any power to make laws, orders, regulations, bylaws, notification, etc. And the local authorities, you may know, it is the municipalities, district boards, etc. Now, you see, the expression of the authority, it has been brought to the court for the interpretation, for the proper interpretation. A court has preferred initially a very, a narrow view. If we will see, in the case of the University of Madras versus Santabai, the Madras High Court held that the it could be only authorities exercising governmental or sovereign functions. You see, in this case, adjustum generis rule was laid down. It was very narrow interpretation given by the court. It said that it could indicate those authorities of like nature adjudice generis. You see, it could not include persons natural or juristes. You see, the main question in this case was whether a university is a state or not, and it was held that the university cannot be brought under the ambit of the state. Now, in the later case, electricity board Rajasthan versus Mohanlal, and the Supreme Court preferred a broader interpretation. Rather, the Supreme Court said that those authorities which are created by the Constitution or by statute, on whom powers are conferred by law or the authorities, right? Subsequently, in the Sukhdev Singh versus Bhagatram, Justice Matthew, in a separate in concurring judgment, preferred a broader test that if the functions of the corporation were of public importance and closely related to the governmental functions, it can be treated as an agency or instrumentality. It was it this thing this idea was given by this observation was given by the Matthew, right? And the coming case which I'm gonna discuss, that is Ramana Dayaram Shetty versus the International Airport Authority of India. In this case, uh, a more broader and liberal interpretation was preferred. The court said that if a body is an agency or an instrumentality of the government, it may be the authority within the meaning of the article 12. Now it was said, it was observed by the court. Now the question is, what is agency, what is instrumentality? As I said you that this was observed by the Matthew, that any corporation whose function is or public importance or closely public importance and closely to the government and function as, it should be treated as agency or instrumentality. These terms, these expressions were used by the Matthew. But the question arises here: what are the agency? What is an agency? What is an instrumentality? You see, a test was laid down by the Supreme Court to determine whether a body is an agency or instrumentality of the state. Now, the five tests were laid down by the Supreme Court. The first test is that is, if the financial resources of the state is the chief funding source. You see, this is the first test, and the second test is existence of deep and pervasive state control. The third is functional character being governmental in essence, right? And the fourth is department of government is transferred to a corporation. And the last one is whether the corporation enjoys monopolized status, which is state conferred or state protected. these are the five these are the five tests which were laid down by the Supreme Court to determine whether a body is an agency or an instrumentality, right? So we can say, if a body is an agency or an instrumentality, it can be brought under the ambit of the authority. It can be said that it's under the definition of the state, right? You see, this is understood: financial sources of the state is the chief funding source. It is understood that is entire share of capital. You see, the entire income is coming from the government. And the second test, that is existence of deep and pervasive state control, that is The agency, the instrumentality or agency is it is under the control of the state. And the third test is that is functional character, being governmental in a sense, that is the functions of any concerned agency or instrumentally of the public importance, you see. and the and the and the fourth one is government of the you see government of government department of government is transferred to a corporation. And the fifth one is whether the corporation enjoys monopoly status, which is state conferred or the state protected. This test was first applied in Sam Prakash versus Union of India. So uh, you see, now it is clear. It has been cleared by the Supreme Court, and tests have been laid, and to determine whether any body, whether any authority is under the ambit of the state. Now it is very easy to recognize any agency and instrumentality, and tests have been laid. And if there any any doubt arises in future about the definition, about the role of any agency, whether the concerned, whether that agency is under the ambit of the state, whether the action is of that agency, whether the action is of that instrumentality can be challenged under the under the fundamental rights. So this was all about the definition of state under Article 12, and I hope you got it. I hope you. I hope this discussion was very beneficial. This was very useful for me as well as you. And in the coming lecture, in the coming days rather, I'm gonna bring more videos about the fundamental rights, and like Article 13, Article 14. Those articles are very important. So I hope uh, this will be very beneficial for you. Thank you.